Welcome, I'm Jamie Napier, Chief Assistant Clerk of the Board. Thank you all for coming to our training on open meeting laws for Contra Costa County's boards and commissions. This training will fulfill the requirement for advisory body members on the Brown Act and Better Government Ordinance. Training certification forms are on the Clerk of the Board website and are printed near the sign-in table. Please return your completed training certification forms to your advisory body staff person. In addition, for any attorneys in attendance, this training is approved by the State Bar for 1 hour of mandatory continuing legal education credit. Please be sure to check in to receive MCLE credit. In this training, we will discuss open meeting laws, specifically the Brown Act and our local Better Government Ordinance. Our speakers tonight represent 3 different county departments that perform 3 different functions: County Counsel, District Attorney, and Clerk of the Board. Clerk of the Board is here to offer support and training to help our board staff and members follow all applicable laws and policies. We can also assist with the appointments process, the context and scope of advisory boards, the bylaw update process, and roles and responsibilities of staff and members of boards and commissions. We can also assist with posting your agendas, answering day-to-day questions, and provide training to boards and commissions on topics within our purview. Please feel free to reach out to our office with any questions regarding boards and commissions by calling 925-335-1900 or visit our website. We will now hear from 2 extremely knowledgeable and dynamic presenters. Chief Assistant County Counsel Marianne Mason has advised county bodies about how to comply with the Brown Act since 1987. Deputy District Attorney Steve Bolin has addressed complaints about Brown Act violations by a wide variety of public entities beginning in 2001. After handling other assignments, Steve is once again the point of contact for Brown Act inquiries for the District Attorney's Office. They are here to share their experiences with you and to help identify best practices for legal compliance with the Brown Act and Better Government Ordinance and transparency in public meetings. With that, I will turn it over to Marianne.
Good afternoon. Thank you for coming today. I always like to take a show of hands. How many people have attended or viewed this Brown Act and Better Government Ordinance training in the past? Great. We have a pretty experienced group here, so we'll really be able to delve into the difficult stuff. First, I'd like to talk to you about the legal framework that supports our open meeting laws. What is an open meeting law? It is a law that is designed to promote transparency in government. Its purpose is to give the public advance notice of what government bodies are doing and to foster public participation in our process. I have to say that all of you are really important participants in our democracy. You are the first line of civic engagement, and you are serving a really important role. So I thank you for helping people to participate in their government and for helping it to be transparent, at least at the local level. The open meeting laws set out rules that require the Board of Supervisors and its various advisory bodies and various statutory bodies to take certain actions in order to ensure public participation. There are 2 open meeting laws that we'll be talking about today. The first is the Ralph M. Brown Act. It's found in the California Government Code, and it applies to all governing bodies that are local, like city councils, boards of supervisors, special district boards, school district boards, statutory bodies like planning commissions, the Mental Health Commission. And then there are other laws, our Better Government Ordinance, which is a local ordinance adopted by the Board of Supervisors that expand the state Brown Act. And the local law enhances access, it expands requirements to bodies that aren't covered by state law, like temporary ad hoc subcommittees, basically expands open meeting rules to all types of bodies appointed by our board and by its advisory bodies. So you have to wonder, who is subject to the act? Basically, in our county, the open meeting laws apply to the board, its subcommittees, its advisory bodies, all of their subcommittees, even if the subcommittees are temporary or ad hoc. When do these laws apply? Every single time that there is a public meeting. Here's the rule, succinctly stated. You'll see it down in bold at the bottom of the PowerPoint there. Members of a board, committee, or commission may only discuss the body's business at properly noticed meetings that the public can attend. A good question to ask whenever you have a quorum of a body or a quorum of a subcommittee is, are we meeting? Because meetings can occur unintentionally if you're not careful, and then you're in violation of the Brown Act and the BGO. According to the Brown Act, a meeting is any congregation of a majority of the members of the body at the same time and place where they hear, discuss, deliberate, or take action on any item within the body's jurisdiction. Even the simple receipt of information about matters within the body's business by a majority of the board or the commission is a meeting. So if you have a group of commissioners all sitting down at Starbucks having coffee together, let's say you have 3 of your 5 planning commission members, they're all there having a coffee, and their conversation happens to stray to, well, at our upcoming meeting, we have the matter on the agenda involving this particular decision. What do you think we ought to do? Suddenly, we have an illegal, unnoticed meeting at Starbucks. That's why I want you to be really aware of when a meeting can occur. You could have a meeting that you have properly adjourned, and everyone can go out to the parking lot afterwards, and 3 of your committee members can stand around and talk to one another about things that happened at the meeting and what they think ought to happen next, and suddenly we have another meeting. Again, it's really important to be cognizant. And the central rule here is that a majority shouldn't be discussing the body's business outside of an open and noticed meeting. It's important to note that the body doesn't have to take action for something to be a meeting. The simple exchange of information or discussion of views, as long as the topic is something within the body's jurisdiction, is enough. Now we move to one of my favorite questions. Can't we just do it by email? We live in a very electronically connected age. We engage with one another electronically much of our day. And sometimes it just seems like it would be so simple to handle these small things by email, not have to convene everyone. But the Brown Act gives a resounding no. The Brown Act says that a majority of members of a body cannot use social media or intermediaries to discuss, deliberate, act on, or receive information about a matter in the body's jurisdiction. So it's not okay to be texting with a majority of the members of your body, or to be emailing with them, or to be having a Facebook or Instagram exchange if you are talking about the body's business. It's also not okay to be doing this on a seriatim basis. Let's say, for example, that the text is only between two members of the body. Well, then one of those two goes on and texts another one. Here's my view, and here's what so-and-so said to me. What do you think? Now we've got a majority of the body involved. This can easily happen by email. You have to remember, it isn't necessarily just a group communication. It could be a series of communications. Our general advice to ensure that people comply with the law: stay off of text and email with a majority of the body whenever you're dealing with the body's business. There are certain exceptions. One important exception is for all the people here who are staff to bodies. Staff is able to answer an individual member's questions about things, and they are able to provide information. And there's a specific exception in the Brown Act that allows that, and that allows staff to talk to more than a majority if that is necessary. But it's done on a one-to-one basis, and staff is not able to share the questions that other members of the body posed, or to share the views of other members of the body, or to try to form a consensus. And for those of you who are members of the body, you should never try to put staff in the position of doing that. Some other instances that are not a meeting: individual contacts between any member of the body and the press, or a constituent, a member of the public. That's a specific exception in the Brown Act. So it is possible that a constituent could talk to each member of the Planning Commission if the constituent wished to do so. That would not be a Brown Act violation. On the other hand, we can't have one staff member being used as an intermediary by all of the commissioners. That's the serial meeting that we were talking about. Another exception, another time when it's not viewed as a formal meeting, is when you have a majority of your members attending a conference, something like this today. It's been noticed, it's open to the public, it's of interest to bodies, so if there happens to be a majority of any of your bodies sitting here in the room today, that's not an illegal, unnoticed meeting, as long as you're participating in the forum and you're not talking to one another as a group together about matters within your business, sort of off agenda. So usually we say, sure, it's fine for everyone to go to the training session, but don't all sit together. You know, spread yourselves out so you never get into the position where somebody says that you were talking out of turn. Meetings also don't include social and ceremonial occasions, as long as nobody strays into the public's business. So for example, if a commissioner wishes to host a holiday gathering and invite some friends on a commission, and that happens to be a majority, that is not a meeting unless people start talking about topics they shouldn't be discussing. Again, it's really important to be very careful. When the county or a county body sponsors an event, like a holiday event or a ribbon cutting or something, and a majority of the body is invited to attend, although it may not be a meeting, our Better Government Ordinance says that it is a gathering that the public must be permitted to attend. So if you wish to sponsor at your community services district a little celebration of something or other, just be aware that members of the public are entitled to come. And frankly, as we were discussing, if you really want to encourage public engagement, you wouldn't do any kind of a public celebration as a body that didn't include the public. Don't assume an exception applies. You can always ask your staff to check with our office. We're happy to help you and help you figure out whether what you have is a meeting or not. Now let's talk about how to prepare for a meeting. The first issue is, where can your bodies meet? Starbucks? Generally, no. Meeting locations are restricted by the Brown Act. They have to be held within the jurisdictional boundaries of your body. So for example, if you are a MAC, let's say it's the Alamo MAC, your meeting should be held within the jurisdictional boundaries of the Alamo MAC. In addition, where you meet needs to be open to the public. Members of the public cannot be required to pay or purchase in order to attend. This is why restaurants are generally not a good choice. A body cannot hold meetings in facilities that are not accessible to the disabled, and a body cannot hold meetings in facilities that prohibit members of one gender or one race from entering. So a women's club that doesn't allow any men to enter is not a place that you could ever meet. The Better Government Ordinance requires one additional thing, and that is overflow capacity. If you look here, if you were to leave the board chambers, say there wasn't enough room in the board chambers, there's plenty of room in that hall, and there are monitors where people can see and hear the meetings as they go on. So you should, if you have an item on your agenda that's going to draw a lot of people, it's a great idea to have your meeting in a place with overflow capacity. The Better Government Ordinance says that if you don't have overflow capacity and the room is too full, you need to adjourn to a subsequent date to a place that's large enough. So think ahead when you're planning. Probably the most important planning that you do involves preparation of your agenda. So, who needs an agenda? Every single body for every single meeting. What goes on your agenda? This is going to sound like a long list, but I do suggest, to the extent you're interested in samples, take a look at the Board of Supervisors agendas. They're really nicely done, thanks to Jamie. And they contain all of the necessary language, and that'll just give you a sample of what agendas ought to look like. First of all, an agenda needs to specify the date, time, and location of the meeting. It needs to provide an opportunity for comment on each agenda item and on any non-agenda item that is within the body's jurisdiction but isn't on that particular agenda. You have some flexibility about where on the agenda you put this general public comment. Some bodies put it at the beginning, some bodies put it at the end, but you must include it somewhere on the agenda. In addition, I think it's a best practice to include any time limits per speaker that your body has adopted so that the public knows in advance how much time they have to prepare for their comments. The agenda also needs to include information on every single matter that the body is going to hear, discuss, consider at that meeting. Really need to think very comprehensively. Don't assume you can just add something. We'll talk about that more later. Agendas also have to have certain statutorily required information. One thing is they have to tell people how to request an accommodation. That could be requesting meeting materials in a particular format, like Braille, or closed captioning, something like that, or other sorts of accommodations. Agendas also need to provide a location where the public can see a copy of documents that were distributed to the body after the agenda was posted. So for example, on our ADA language, on the front page of every agenda, you'd have something like, the Planning Commission will provide reasonable accommodations for all persons with disabilities planning to participate in meetings who contact, and then you'd give the name of the committee chair or staff, at least 48 hours before the meeting, and then provide the contact information. And you'll see this on sample Board of Supervisors agendas, which are on our website. And then something like, any disclosable public records related to an open session item on a regular meeting agenda and distributed by the Planning Commission to a majority of members less than 96 hours prior to the meeting are available for public inspection at. Again, you're trying to enhance the public's ability to participate. So these generic statements that I do think most of your bodies now have folded into your agendas need to be on each and every one. Next, let's talk a little bit about agenda item descriptions. And I want to commend to you one of our handouts, some information put together by my boss, Sharon Anderson, the County Counsel, who's here today. Information for our departments about how to prepare agenda items I think would be helpful for all of you. The agenda must contain a brief general description of each item of business to be transacted or discussed. According to the Brown Act, the description need not exceed 20 words. So you don't need to go on for paragraphs to adequately describe something. Descriptions must use clear language that is not misleading or opaque. They need to be sufficiently descriptive to tell the public what the item is about, and they need to allow the public to decide whether to attend and comment. They need to be succinct, though, and not overly detailed. So here's an example of a recent case. It involved a community services district, and it had, it's called Olson versus Hornbrook Community Services District. It had an agenda item for approval of bills, and it said, approve the following 4 bills. Well, the CSD board approved 5. And then the next agenda said, approve payment in the amount of $85. But instead, the Community Services Board approved payment in a different amount. And the final agenda said approve bills incurred between 2 certain dates. Members of the public sued, claiming that the body was improperly authorizing payments. And you have to be aware, there are people who will be concerned and who will challenge, and as Steve will tell you later, will file complaints about how your agenda item descriptions do not line up with the actions you're taking. In this case, the court said, you know, you listed specific bills on the agenda. You said you were paying 4, you paid 5. Nope, not consistent. That was overturned. They said, you're paying one amount, instead you paid another. That action was overturned. But where the body built in enough flexibility for itself, but still met that balance of giving the public notice and said, approve bills between this date and that date, the court said, no, that was appropriate and upheld that action. So you're looking for a balance. You don't want overkill in your descriptions, but you also don't want too little. Something that just blankly says report on legislation doesn't tell the public very much. But something that says receive report on the status of AB 243 and SB 17 alerts the public to exactly what you are going to be talking about. And if you want to give it a little more breadth, you could say, and other bills, pending bills of interest or something like that. So once you've finally gotten your agenda together, what do you do with it? In this county, because we have the Better Government Ordinance, that applies to all of our county bodies. You must post your agenda 96 hours in advance. The normal Brown Act rule is 72 hours, and that applies to things like the County Board of Education. But for bodies that are specifically under the jurisdiction of the Board of Supervisors, it's a 96-hour posting period. You have to post in two ways. First, physical posting on a building or on a kiosk, and it needs to be a posting that members of the public can see during the entire 96-hour period. They need to be able to walk up to that building and see it. It can't be something that's locked inside a hall that they can't see during your off hours. And then if your body has a website, post on the website. For some bodies, governing bodies, like fire district boards, housing authority, board of supervisors, city councils, county board of education, you need a direct link from your home page to the agenda. For other bodies, we highly recommend that you use a direct link because it's simply the best practice. That makes it really easy for people to find your agenda. And if your body doesn't have a website, and I know some of the smaller ones may not, you can work with the clerk of the board to do posting through the county website. So I highly recommend you check with Jamie, our clerk, if you don't have a website, and even if you do, more posting is better than less. If you haven't posted in both of these ways, no posting, no meeting. That's sort of our black letter rule. So be really careful about your posting. What do you do with your agenda packet? You have your agenda, you have your staff reports, the things that go behind it. You must make sure that the staff reports and other materials prepared or forwarded by staff for the meeting are available to the board or advisory body and the agenda requester list at the same time. That's really important. You can't provide things to the body days and days in advance and only give things to the requester list at the last minute. The Brown Act specifically requires that it be at the same time. In addition, as soon as your materials are complete, our Better Government Ordinance says that they must be publicly available, even if they haven't been handed to the body yet. Again, that's only for bodies subject to the Better Government Ordinance. Have a hard copy available at your front counter for members of the public who want to come in and take a look. Not everyone is tech savvy and uses a computer. I know it seems that way, but you should still be prepared for people who aren't. Just a quick note on the agenda requester list. Anyone can ask to receive your agendas, and that request is good for a year. And so you have to remember that and honor that. And most entities these days tend to send out an email to the agenda requester saying, are you willing to accept our documents by email? And agenda requesters will generally say yes, saves paper, saves time, and then they tend to renew that same way. Remember that your agendas and your agenda packets are public documents. The public is entitled to see them unless they contain privileged material. What about late documents? This happens to all of us from time to time. We can't get everything ready. Staff doesn't have it quite finished the full 96 hours in advance or the full 72 hours in advance. What do? The Brown Act says that for open session items completed less than 72 hours before the meeting, they need to be available to the public in the location specified on the front of the agenda. So for the Board of Supervisors, that's the clerk of the board's office, as well as the website. all of you need to specify a place that people can go to see a late prepared document and be prepared for people to come and see it. The Better Government Ordinance requires staff materials be available 96 hours in advance. But when that's not possible, the ordinance also sets up a procedure for requesting permission from the body to accept late documents. So you ask at the meeting that the body waive the 96-hour timeline and accept the document. When you make your request, you are supposed to have a written explanation for why the materials are late, and the body needs to act by a 3/4 vote to waive the time limits and accept the late documents. In part, that is because they want this process to be a little bit difficult. They don't want people doing things late, so there are a few hurdles in the case of late documents. What do you do if a disabled person requests an accommodation? Let's say staff receives a phone call requesting an accommodation. Don't ask the nature of the disability, and don't ask someone to put a request in writing. Find out what is being requested and then check in with the clerk of the board. They have an ADA intake form that you can complete. They can work with you on accommodations that could be made. Once you have that information, then respond to the requester. If you receive a complaint that your body has failed to comply or has not accommodated properly, please have your staff get that to the county's risk manager right away. Here's another favorite. Help! Someone wants to teleconference. I cannot tell you how many times I have been asked, can Commissioner so-and-so just call in from his car? Would that be okay? And the answer is always no. I see you shaking your head no out there. That is absolutely right. There are very specific rules for a teleconference meeting. First, you have to have a quorum participating from locations within the body's territorial boundaries. So, for example, the Alamo MAC. It's a 7-member body or a 5-member body. Let's say it's 7. That would mean 4 members need to be within the territorial boundaries of the MAC. And then for those persons who are teleconferencing, their teleconference locations need to be listed on the agenda. So if you think you might like to teleconference from your home, think about, do you really want your home address posted on an agenda? Probably not. The teleconference location has to be accessible to the public. Again, do you want the public traipsing through your house? Are you set up for any member of the public to appear and attend? You also need to be able to post the teleconference agenda and location on the regular agenda and have it done 96 hours in advance. So if you're just calling in from your car, no one would know where you were, and you'd never be able to meet the time requirements. Finally, the public must be able to address the body during public comment from the teleconference location, and they need to be able to hear everything going on at the meeting. That means the teleconference location needs a speakerphone or video conference access. Finally, so that the member of the public who just happens to have come to the teleconference location can know what the vote is, all votes need to be taken by roll call. So finally, we get to the meeting. What rights do members of the public have? They have the right to observe. All meetings must be open and public, and all persons must be permitted to attend. Members of the public have the right to anonymity. You cannot require them to sign a sign-in sheet. You can have a sign-in sheet, but it needs to say it's voluntary. Members of the public have the right to record meetings or videotape meetings, and they have this right as long as they're not disruptive. These days, where anyone can just hold up a cell phone, it's really hard to argue that recording is disruptive. So be prepared for that to happen. They have a right to read, and this means they're entitled to see the agendas, agenda materials, documents that are handed to the body during the meeting, unless they're otherwise privileged. Most important is the public's right to comment. They have an opportunity to address the body on items that aren't on the agenda but are within the jurisdiction, and they have the opportunity to address the body on every agenda item either before or during the body's consideration of that item. A good protocol is to call the item, have the staff report, then take public comment so that the public is able to comment on what they've heard the staff say, and then have it go to your body after staff comment for discussion and deliberation. Members of the public also have the right to even-handed application of the rules. So if you have a rule per speaker of 2 minutes apiece, you cannot allow people you like to speak 5 minutes and cut people you dislike off at 1 minute. It needs to be even-handedly applied to all. If you have rules limiting public comment and you do not have simultaneous translation equipment, persons who need to speak through an interpreter or a translator receive double the time for public comment. So just remember that. That is becoming more and more common at meetings. Finally, the public has the right to criticize. And I know we all enjoy that, but it's absolutely important for the strength of our democracy. The body cannot abridge criticism of the agency's policies or procedures or programs or services, or of its own acts or omissions. However, you are entitled to apply your rules of time per speaker. So you can listen to someone who's very unhappy with you for 2 minutes, and then you're able to say, all right, it's now time to move to our next speaker. But we really need to talk about this. What if there's something that you forgot to put on your agenda, and you just feel that you need to speak about it at that particular meeting? Unfortunately, you have to follow the posted agenda. If an item is not included on the agenda, the committee may not act on or discuss that item except in very limited circumstances. So plan agendas carefully and don't assume you can add. Deviation from the agenda is allowed in just a couple of instances. If during public comment, a member of the public raises a matter not appearing on the posted agenda, the body's members can make a brief response, and I do mean brief. The body cannot act on or discuss the matter. There's no ability to just suddenly take an action based on something that was said during public comment, except in one possible circumstance involving threats of litigation, and that is not going to apply to most of you most of the time. However, a member of the body can ask the commenter a question for clarification. They can provide a reference to staff or other resources for factual information. They can request a report back to the body at a subsequent meeting or request placement of a matter on a future agenda. So these are very brief interactions. They're just intended to move something to a time when it can be properly noticed. The other circumstance when the body could deviate from the agenda is when there has been a determination by 2/3 of the body that there is a need for immediate action, and the need came to the attention of the body subsequent to the posting of the agenda. This almost never occurs. I can think of very few times when this standard is met. One that comes to mind is a situation where an agency became aware of a grant opportunity that required a resolution of a board after the agenda was posted. And the grant deadline was going to be before they could meet again. That was a circumstance where something could be added, but you have to meet a number of criteria. If you think this exception would apply, call our office. We'll help you sort it out. Finally, we get to voting. How about secret ballots? It might be more comfortable than having to state your positions publicly and go through a roll call vote. But the Brown Act says no secret ballots, and you have to report individual votes by name. Voting has to occur in public. Each member's vote must be visible. A roll call vote assures compliance with this. If a simple vote is called for, then members of the public must be able to see the yeas or nays, and the board secretary needs to record them. And it's a really good idea for the chair to say, okay, following that vote, we've had 3 members, members Smith, Jones, and Black, who voted yay, and we've had 2 members, members Brown and Jones, who voted no. Finally, what about your minutes? They need to reflect the aye, no, absence, or abstention of each board member by name for each vote taken. What's the policy reason? Again, the right for the public to witness the decision-making process. If you want to hold a closed session, have your staff call us. The ability to hold a closed session is really strictly limited. It only is authorized at specific times provided in the Brown Act, and it's only to give the body's members the opportunity to discuss something that would prejudice the agency's position if it were discussed publicly, or that would infringe on individual privacy interests. Some examples might be a public security consultation, consultation with an attorney on pending litigation, consultation with a negotiator on real property price. Most advisory bodies never are going to be in the circumstances of having to deal with those issues. So that is why I say, contact us if your advisory body is even thinking that there might be a basis for a closed session. If there is, we'll provide the agenda language and we'll help you with announcements out that may need to be made after the item and before the item. So to wrap up the conduct of the meeting, how detailed should your meeting minutes be? They absolutely do not need to be verbatim. Brief minutes are just fine. Use of an annotated agenda works really well for most bodies. The minutes do need to accurately reflect what the agenda was, what actions were taken, who made a motion, who seconded, and what the exact vote was, including names of each member and how they voted. And that gives the full picture to anyone who wants to look at your minutes and see what happened. So those are all the how-tos, the many rules that are out there. And most of them are summarized in this PowerPoint. Now I'm going to turn it over to Steve Bolin, Deputy District Attorney, who will talk to you about what happens if you happen to violate the Brown Act. Thank you. Steve?
Thank you, Mary Ann. I think I could use a musical cue when I start out with that part, right? Like some da-da-da-da music when the DA is going to come up here now and tell you all the things that could go wrong with your Brown Act. Sure, thank you for that. I can tell you some things about how the enforcement part of the Brown Act is going to work for you. Is that good? But the first thing you should know and be reassured about is I get many complaints about the Brown Act as part of my duties. And very rarely do I get complaints about county agencies and boards. And partly, I think, maybe directly due to the training we do in Contra Costa County and the fine legal representation you can rely on from the county counsel's office. You're very rarely going to run into a problem with violating the Brown Act, in my experience. However, I deal with boards and city councils and school boards and water boards, reclamation districts who don't have that level of training and don't have the resources of counsel to help them follow the rules of the Brown Act. And so I get complaints about that. And that's where the district attorney's office comes in. As a county agency, one of our responsibilities is to make sure that the Brown Act is enforced and that it's followed. And as I said, I will get complaints from citizens throughout Contra Costa County complaining about Brown Act violations. And so I'm going to walk through some of those complaints with you so you have an idea of what's out there. As I said, I'm confident. The fact that you're all here reassures me that you want to make sure you're doing the right thing. And 99.9% of the people that do this as a volunteer. They do this because they want to help their community and they want to do the right thing. And as long as you're along that path, you're going to be fine with Brown Act violations. You're never going to see me again. You're never going to hear from me again. And it was nice meeting you all. This part of the presentation will also be much shorter because you are so well trained now. You have this PowerPoint, you've got the materials we provided, and you've got access to lawyers if you have a question. So enforcement's not going to be as crucial for you to remember, but let's walk through it just so we're all aware of it. When I get letters or calls from the public complaining about Brown Act violations, first of all, I ask that they be put in writing because I want to be able to look at them a little more carefully than just over a phone call. And I want to look at them through the lens of the law, and I want to also talk to that lawyer that represents that board or commission if one is available, just to find out what the reasoning was of that board in taking the action that the board took. Most often what I can do is send a letter to that board or commission and say, here's a complaint I received, and what was your thought process in taking this action? Why wasn't the agenda posted in this time period? Why did you go into closed session? Why did you not allow public comment on a certain topic? And usually those can be cleared up very quickly, and that is the majority of the complaints I get are things that we can deal with very quickly. Every once in a while, however, there is a violation of the Brown Act that has consequences for that community, and action needs to be taken. And oftentimes, again, because we're dealing with people who are trying to do the right thing, we're able to deal with that in a voluntary manner. People want to correct the mistake they made and do things the right way. Every once in a while, very rarely in Contra Costa County, civil action needs to be taken, where we'll go to court to ask a judge to make sure the Brown Act is being followed by a board or commission, council. That's very rare, but that is an option we have, and we will talk about that here now, about how we take that action. But finally, California takes the Brown Act so seriously that if there is a violation of the Brown Act that is so serious and fits certain criteria, members of that board can be charged with a crime. You can be criminally prosecuted for a violation of the Brown Act. So thank you all for volunteering and taking your time to be here, and we'll see you in court. Obviously, that's not our intent, and we'll talk more about, but I want you to be aware of that. And I think the idea of it is that we want the public to know that we're taking open government very seriously. So let's first start talking about civil remedies that are available to us. The first thing I can ask the court to do if I find that there's a problem with the Brown Act is ask the court to invalidate the action. Invalidation is my first step that I can take in seeking court assistance. This is when enforcement by my office would result in a judicial determination that the action taken is null and void. So your board took an action and you're very proud of it, and we're going to go forward with this new approval that you just gave, and I'm going to go to court to stop it. That's my role because you and I disagree on whether or not that was a violation of the Brown Act. We're going to have a court determine that. This applies to some very specific areas. I've listed them there for you, and we'd get into them in more detail if we needed to, but it has to usually do with open and public meeting requirements. Did you let people know where the meeting was and let them know where they could meet? Did you post the agenda of a regular meeting? Did you follow rules with special meetings? Did you follow the rules required for emergency meetings? The common one that Ms. Mason did warn you about is closed session violations. Closed sessions, all of us, right, are suspicious when people go back behind the door somewhere and come out with a decision. That makes Americans nervous, I think. And that's the kind of complaint I get a lot, are people saying, what just went on in closed session? They came out and something happened, and I think something wrong happened with the Brown Act. That's why you're going to be very careful about ever going into closed session. And most of you won't need to, but once in a while it's going to be necessary. And finally, there's an exception for public testimony not being allowed prior to a new tax or assessment. Very rare did I ever see a complaint about that. But I'm going to go to the next page now and tell you how this actually takes place. Prior to enforcement action, before I go to court and file that complaint asking for the judge to intercede and help me make sure the Brown Act's being followed, the district attorney has to make a demand of the legislative body. And that demand is to cure or correct the action. And that's kind of a buzzword that we use here in the Brown Act community. Well, there's no such thing as the Brown Act community, but let's just say that that's a common term that we use in enforcing the Brown Act, is making sure that the commission or board cures or corrects the incorrect action. And that's the language we use in the statute. I need to make a written demand of your board within 90 days of when the action was taken, or if the action was taken in open session but in violation of the agenda posting requirement, the demand has to be made within 30 days. So for those agenda violations, 30 days. So it's a quick turnaround sometimes, because sometimes a member of the public takes a little while to formulate who to even contact if they think there's a Brown Act violation and try to find me, and how do you figure all that out? It takes a few days. I finally get it. I ask you to put it in writing. That takes a few more days. But we have a clock running that if I do need to take action, if something serious happened here and the board's not going to correct it, I need to be able to take action quickly. So we're going to move fairly quickly on these cases. Within 30 days of the receipt of the demand, the legislative body shall cure or correct the challenge action. But if no action is taken or it's refused, the district attorney has 15 days to commence a civil court action. So once I've let you know that I think there's a problem here and your lawyers looked at it, we have 30 days to get this back on the agenda and do it right, or to come to an understanding of what actually happened and that it was not in violation of the Brown Act perhaps, or you may just ignore me, and that's probably not a great option, but if you do, then I've got 15 days after that 30 days is run to file something against you to get you into court. I've got another option as well, which is I can take civil action to prevent future violations. and this is a specific section of the government code that says I need to stop or prevent violations or threaten violations of the Brown Act. And that's the one I'm going to see most often, probably, from the public. There was an example of a board that took public comment after they took their vote. So they said, no, we're complying with the Brown Act. Everybody can talk, but we're going to go ahead and get this thing taken care of and vote, and then you can all come up and tell us what you want to tell us. And they said, under the statute, that's fine. As long as we allow public comment, we're fine. Well, obviously, that's not going to work, right? So that's their policy, and they came back with a letter to the district attorney in that county saying, no, that's what we do. This is the right way to do it. And that was when the DA took action to prevent future violations of the Brown Act, saying you can't limit public comment in that way. We can also use the courts to determine whether the Brown Act applies to certain actions that were already taken. That you say, no, we did everything right, and we're fine with that. There's no problem with the Brown Act in this case. I can have a court come in and make a determination that, no, going into closed session in that situation was not proper. And as you skip to the last point there, one of the things I can ask the court to do is compel you to record your closed sessions. Let's find out what really is going on in that closed session. I'll have a judge listen to it and determine whether or not you're doing the right thing or not. That will, of course, help make sure that you do the right thing, I think, and that's the reason we have that in that statute. And finally, the third one there that I skipped over is determine whether any rule or action of the body to penalize or discourage the expression of a member is valid. And this will take place most commonly where you've got a split board, 4-to-1. One person was appointed by a political opponent of the other 4, some such thing. And the 4 are conspiring in a way to keep the 1 from being able to exercise their rights in public meetings. That's very rare, but it's an option I have. So let's get to the part where I told you I need the music cue, which is the criminal penalties, the dun-dun-dun-dun part. Here's the statute. It's Government Code 54959. Don't write that down. You're never going to need that to know that section. But here's what it says. Each member of a legislative body who attends a meeting of that body where action is taken in violation of the Brown Act and where the member intends to deprive the public of information to which the member knows or has reason to know the public is entitled to under the Brown Act is guilty of a misdemeanor. So I can charge you with a crime, just like a petty theft, like a driving under the influence, like a simple battery. It's a misdemeanor with a penalty of up to 6 months in jail. Amazing, right? We take the Brown Act very seriously in California. Let's break it down, though, a little bit. First of all, it's each member of a legislative body. So I'm not charging the Planning Commission or the school board for violating the Brown Act. I am charging John Public, Jane Public, Bob Public, whoever's on. I'm charging you personally with a crime that you're going to go to jail for potentially. So it's your liability. The next requirement, who attends a meeting of that body where action is taken in violation of the Brown Act. That's when it's good to be absent that day when that happened, because you have to be present at that board meeting where the action was taken. So just because you were on the board when an action in violation of the Brown Act was taken, I can't charge you with a crime unless you were actually there. And where the member intends to deprive the public of information to which the member knows or has reason to know the public is entitled to under the Brown Act. So this is going to come up where I've gotten complaints about your board in the past. I've been writing letters to you and to your legal counsel. We've been trying to work this out. You and your counsel disagree and say, no, Steve, you were wrong. You're not doing it the right way. We're going to keep doing it this way. And I keep saying, no, you can't. You're in violation of the law. That's where we get to that extreme time where I'm going to think about charging you with a crime because you're acting in violation of the Brown Act. And you have to know that or have reason to know. And one of have reason to know means you've gone to this training. So now you're all on notice, right? You all know what the Brown Act requires of you, and you're going to violate it anyway. This is so rare, right? Can you imagine? And this would be kind of a runaway board. This would be probably, and I've dealt with some of the smaller agencies. There's reclamation districts, there's small school boards, there's small water districts where people have done things the same way for a long time, and the public has never given them a hard time about it because it's not that big a deal in their community. All of a sudden, something becomes a big deal. A piece of real estate that they're responsible for becomes valuable, and they decide we're going to do it this way. And we've never had a problem with the past, and the DA doesn't know what they're talking about. That is what I would imagine would be the kind of time where I need to think about taking criminal action. Let's look at some of the exceptions to that, though. Action must be taken. So mere deliberation without action is not subject to criminal penalty. And so I need you to take an action. I need you to sell that piece of property, not just talk about selling that piece of property someday. And by God, if we could, we'd sell that piece of property. That DA doesn't know what he's talking about. We should do this. Well, not a violation of the Brown Act. You're upset with me, but that's not going to violate the Brown Act. You need to do something, take some affirmative action before I can look at charging you with a crime. You must intend to deprive the public of information. So it can't be just that you didn't know that rule, or you forgot that rule, or you misunderstood the rule. You could have a lot of ways around that, and I'll give you two examples. One is stupidity as a defense. That would be, we just didn't know. Now, you guys are all here, so you're all responsible for this now. So maybe you should have stayed home. You could have been watching the debate right now instead of being put on notice for criminal charges. But stupidity is defense, and I mean that in this sense, that I just didn't know about that. I'm never going to charge you with a crime giving you that defense. You're going to be on notice. I'm going to have sent you so many letters, and we've been talked to so many lawyers, and we've met multiple times, so we're all going to know what the issues are before I would ever consider charging anyone with a crime. So that's probably not going to be a defense I'm going to let you have. And advice of counsel is a defense. You're going to say, hey, look, my attorney told us they're an expert on the Brown Act, and they told me this is the right thing to do. Again, I'm going to meet with you and your attorneys multiple times, and it's going to take a runaway attorney that you've hired, or you not hiring an attorney if you're a small board or district, and you taking action because you think it's the right thing to do. So that's going to be very rare. And finally, the kicker is the last line I give you there, which is there have been no successful prosecutions of a violation of this statute. Okay? So even though this law's been around for a long time, never happened. So I've tried to scare you and given you the worst case scenario, but as you understand as we talk about this, you all are people of good faith and you're trying to do the right thing. I've got a lot of things to do as a deputy district attorney. My boss has a lot of responsibilities that she takes care of. Do we want to spend a lot of resources talking about whether or not the agenda was posted there or over there? I'm probably not going to charge you with a crime about that, right? We've got other things we need to do. But we just want to make sure you understand we take this very seriously. And if we do get that weird situation where there's a runaway board or a runaway district that wants to do things the right way, that I've got some enforcement action I can take to protect the public and give them the open and transparent government they're entitled to. So although there have been no successful prosecutions, that doesn't mean there never will be. And just think of how famous I could be in the Brown Act community if I'm the guy who actually filed the Brown Act case against you. It would be very exciting, but very unlikely. So let me leave by, again, thanking you all for your service, first of all, to the county or the district or the board that you work with. We appreciate that as members of the community. And thank you for coming tonight. And I think Marianne and I can answer any questions you have. Thank you.